Well, friends, good morning. Jagender Rana here. So, I will discuss today the contributory negligence and motor accident cases. Contributory negligence and motor accident cases. At common law, in old days, contributory negligence operated as a complete defense. Once contributory negligence was established, plaintiff would get nothing. This is called pure contributory negligence. Even today, in a few jurisdictions where this theory applies, plaintiffs get nothing even if he is partially negligent. So, contrary to this, in modern days, in majority of jurisdictions, even if contributory negligence is established, the claimants, even if contributory negligence is established, the claimants will get his damages, but it will be reduced by the court in proportion to his fault. So this is also called comparative negligence in few jurisdictions. So the modern position is more evolved, matured, and logical, because this shift is not abrupt and dramatic, but it has evolved over a period of time through judicial pronouncements and modern legislations, and has its foundation in second logic and scientific reason. So, what is the foreseeability of harm to himself in the contributory negligence? The contributory negligence has been aptly put in nutshell by Lord Denning, that although contributory negligence does not depend on a duty of care, it does depend on foreseeability. Just as actionable negligence requires the foreseeability of harm to others, so contributory negligence requires the foreseeability of harm to oneself. So a person is guilty of contributory negligence if he ought reasonably to have foreseen that if he did not act as a reasonable, prudent man, he might be hurt himself. And in his reckoning, he must take into account the possibility of others being careless. So in this case, the plaintiff was riding on the tow bar at the back of truck excavator when another vehicle hit it from behind, causing injury to the plaintiff. The plaintiff's damages were reduced proportionately to his contributory negligence. There has to be standard of care, not uniform. The standard of cares are not uniform. So in considering whether the claimant was contributory negligent, the test is basically an objective one, although subject factors are taken into account in case of children and persons under a disability of dilemma. Say in Go versus Thor in 1966, 1 WLR 1387, the plaintiff was aged 13 years. A lorry driver signaled to her to cross the road. She did so without stopping to see if the road was clear. She was run over by a car traveling at excessive speed and overtaking on the wrong side. So it was held that the plaintiff was not guilty of contributory negligence. If she had been an adult, the position would have been different. So the Lord Denning said a very young child cannot be guilty of contributory negligence. An older child may be, but it depends on the circumstances. A judge should only find a child guilty of contributory negligence if he or she is of such an age as reasonably to be expected to take precautions for his or her own safety. And then he or she is only to be found guilty if blame should be attached to him or her. In case of pedestrians negligence, in Capman versus Hersey, 1969, 3, all ER 1528. This is the citation of the case. So the plaintiff, a pedestrian, had been struck by the defendant's car while crossing the road. The plaintiff had negligently failed to see the defendant's car approaching. The defendant had a clear view of the plaintiff prior to the collision, but was driving at an excessive speed or failing to keep a proper lookout for both. So the judge found that the plaintiff was 25% to blame. On appeal, the Court of Appeal increased that the apportionment to 50%. So on appeal to House of Lords, restored the finding of the lower court of 25% contributory negligence. Similarly, in Eagle versus Chambers, CA 24 JUL 2003, the claimant was severely injured when run down by the defendant driving his car. She was in Blackpool and drunk and wandering in the highway. But the defendant was himself at or near the driving limit. So she appealed against a finding that she was 60% to blame. It was held that courts have consistently required drivers to recognize that they control dangerous machineries. It would be rare for a driver not to have greater responsibility than a pedestrian for injury. In this case, the claimant would be held 40% responsible. Lady Justice Hale said, the potential destructive disparity between the parties can readily be taken into account as an aspect of blameworthiness, and it is rare indeed for a pedestrian to be found more responsible than a driver unless the pedestrian has suddenly moved into the path of an oncoming vehicle. That is not this case. The court has consistently imposed upon the drivers of a car a high burden to reflect the fact that the car is potentially a dangerous weapon. Helmet defense, you can see. In O'Connell versus Jackson, 1971, 3 all, ER 129, the plaintiff sought damages after an accident. So the defendant car driver had negligently moved into the path of the plaintiff motorcyclist who was injured. The defendant argued that the plaintiff was contributory negligent and not wearing a crash helmet. It was held that once the court had established that the plaintiff was contributory negligent, it then had to allow both for the extent of his responsibility for the injury and the blameworthiness of his conduct in comparison to that of the defendant in order to assess the proper reduction in the damages. It was held that the plaintiff was not guilty of contributory negligence because although wearing a helmet would have reduced the gravity of his injuries, but his conduct was not unreasonable. So the defendant appealed to the Court of Appeal. Now, Court of Appeal held, applying Jones versus Living Query 1952 2QB 608, the plaintiff should have foreseen the possibility of being involved in an accident even though he was driving with care and at a reasonable speed. So although the defendant is solely responsible for the accident, the plaintiff's negligence is relevant to the gravity of the injuries and damages sustained, as injuries of such gravity would not have occurred had he worn a helmet. Therefore, the plaintiff must bear some of the responsibilities for the consequences of the accident, and the amount of damages is to be reduced by 15%. So a motorcyclist does not owe a duty to other road users to wear a crash helmet, but in failing to do so, he is guilty of contributory negligence if he suffers head injury in an accident. He should foresee harm to himself, although there is no risk of harm to anyone else. So similar reasoning will apply where the claimant puts himself in a position which is not dangerous in itself, but he is aware of circumstances which make it more likely that he will suffer harm. This would explain the cases where the claimant accepts a lift with a driver who he knows is drunk. In these circumstances, the courts will find that the claimant was guilty of contributory negligence but not violent to the risk. Seatbelt defense. In Owens versus Brimmel 1977, 2 WRR 1943, the plaintiff and the defendant were friends. And the defendant one night, they both went out with the car, visited several public houses and finally a club. They had both drunk 8 to 9 pints of beer. At 2 a.m., the defendant was driving the plaintiff home, lost control of the car and crashed into a lamppost. Now, the plaintiff was not wearing a seatbelt at the time of accident. So, the plaintiff suffered very serious injuries, including intellect impairment. The defendant and plaintiff's action for damages alleged contributory negligence of the plaintiff for his failure to wear a seatbelt and recklessness as to the possibility that the defendant's ability to drive was impaired by alcohol. But damages were reduced by 20% for plaintiff's contributory negligence. Legal reform for contributory negligences were also there. In 1945, a general power to apportion damages was given to the courts by the law reform, that is Contributory Negligence Act 1945 Section 1 provides, where any person suffers damages as the result partly of his own fault and partly of the fault of any other person or persons, a claim in respect of that damages. Damage shall not be defeated by reason of the fault of the person suffering the damage, but the damage recoverable in respect thereof shall be reduced to such an extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. But to establish the defense of contributory negligence, defendant must prove that the claimant failed to take reasonable care for his own safety and that this failure was a cause of his damage. So in modern days, the apportionment of liability is fixed on the basis, on the function of respective accusative potency and blameworthiness of the parties, plaintiffs and the defendants in major jurisdictions. The trend of recent judgments are departing from the earlier view expressed in Davies that causation is the decisive factor, and now both respective causative potency and blameworthiness are being given equal importance in apportionment of liability in developed countries. Now slowly it has started gaining traction with the judiciary in India also. That action is filed for compensation for the injuries caused by the accident and not for the factors responsible for causing the accidents. Therefore, wearing a seat belt while traveling in a car or wearing a crash helmet while riding motorcycle could have prevented the injuries the plaintiff have suffered in a road accident. The compensation amount must be reduced proportionately for plaintiff's failure to wear these protective gears. So this is all about the contributory negligence and motor accident cases. Thank you very much.